Imagine an international legal drama unfolding, not in some Hollywood movie, but in a real-life family dispute that literally crossed continents. Today, we're delving into a really fascinating South African Supreme Court of Appeal case, KLVC v. SDI. This case, it really shines a spotlight on the intricate world of parental rights, especially for unmarried fathers. And what happens when a child is moved across borders without consent?
It's a crucial one.
Yeah, and this isn't just like dry legal text. It's a story with real people, really high stakes. And it asks these fundamental questions about what it means to be a parent, even when relationships fall apart. So our mission today is to unpack the key insights from this case, the legal issues, the surprising arguments, and what it all means. Whether you're deep into law or just curious, I think you'll find some aha moments here.
Absolutely. And this deep dive is particularly relevant, I think, because it clarifies a really critical area of family law. Specifically, how unmarried fathers automatically acquire parental rights and responsibilities under South African legislation, the Children's Act. And it also highlights the far-reaching implications of international agreements like the Hague Convention on Child Abduction. You'll see how the court had to carefully sift through the facts and figure out what the law really intended.
Okay, so let's set the scene. We have two biological parents. There's the appellant, KLVC, she's the mother, and the first respondent, SDI, the father. Key point. They were never married, never even lived together.
Right.
They have a child, S, born in Durban, South Africa, back in July 2012.
Right.
And the father, SDI, he always consented to being identified as the father. No dispute there.
Okay. Standard enough start, maybe.
But here's where it gets complicated. In November 2012, when S was just 4 months old, the mother took him from Durban and relocated to England.
Wow, 4 months old.
Yeah. And the crucial part, she did this without telling the father, without seeking his permission at all.
And that's the trigger. Taking a child across borders like that, unilaterally, that immediately flags major legal issues.
Exactly. So what happened legally?
Well, the international framework kicked in pretty fast. The father, SDI, he didn't wait. He applied straight to the High Court of Justice Family Division in the UK.
So the English family court.
Yes. And he used the Hague Convention on the civil aspects of international child abduction, 1980.
The Hague Convention. We hear about that a lot in these cases.
We do. It's designed precisely for these situations to prevent wrongful removal or retention of children across borders and ensure they're returned quickly to their habitual residence. So his application was basically asking the English court to order the mother to return S to Durban. He argued his parental rights were breached.
Okay, so the mother obviously opposed this.
She did, yes. She raised two main arguments. First, she claimed the father wasn't actually exercising what the convention calls rights of custody, essentially the legal right to determine the child's residence and day-to-day care. Her argument was he didn't have those rights or wasn't using them. Second, and this is a serious one, she argued under Article 13b of the convention that returning S to South Africa would pose a grave risk of harm to the child.
Right, the grave risk exception. That's a high bar to meet, usually.
It is. So the English court faced a critical question. Was the removal wrongful? And under Article 3 of the Hague Convention, that hinged on two things. First, did the father actually have rights of custody under South African law that were breached? And second, was he actually exercising those rights when the child was removed?
And the English court couldn't just decide on South African law by itself, could it?
No, exactly. They needed clarity from the source.
Yeah.
So they did something specific. In August 2013, they referred a very precise question to a South African court.
What was the question?
It was basically, looking back in November 2012, was it lawful under South African law for the mother to move the child to England without the father's permission or a South African court order?
Very specific. So locking it to that moment in time.
Precisely. The South African court's job was to determine the father's legal status at that exact point, November 2012. Anything that happened after was, for this question, irrelevant.
Okay, so the question goes back to South Africa, specifically the KwaZulu-Natal local division in Durban. What did they say?
They sided with the father. They found he had met all the requirements under a key piece of South African law, Section 21B of the Children's Act 38 of 2005.
And what does meeting those requirements mean?
It means he had acquired full parental rights and responsibilities, just like a married father would have in many respects. And crucially, this included the right to be consulted on the child's removal from the country. So the court said yes, the mother did need his consent or a court order.
And the mother then appealed this decision.
She did. She took it to the Supreme Court of Appeal, South Africa's second highest court.
Right. So for you listening, this is where we really get into the legal nuts and bolts.
Exactly. The core legal issue for the Supreme Court of Appeal was, did this unmarried father, SDI, acquire full parental rights and responsibilities under Section 21B before November 2012? Because if he had, the law automatically views him as a guardian under Section 18 of the Act.
And being a guardian means?
It means his consent was legally required for the child to leave South Africa or even to get a passport. Section 18(2)(c) is quite clear on that. It's a massive hurdle for any parent wanting to relocate internationally without the other's agreement.
Okay, let's break down the Section 21B. What does an unmarried father actually need to do to get these rights automatically?
Right. The Act lays out 3 key things. And importantly, it doesn't matter if he ever lived with a mother. First, he has to consent to be identified as the father, or apply to be identified, or pay damages under customary law. But usually it's about acknowledging paternity, being on the birth certificate.
Okay, simple enough. What's second?
Second, he needs to contribute, or at least show he's attempted in good faith to contribute to the child's upbringing for a reasonable period. Upbringing is quite broad: time, care, involvement.
Good faith attempts. That sounds important. And third,
similar idea but focused on money. He needs to contribute, or attempt in good faith to contribute, towards the expenses related to the child's maintenance, again, for a reasonable period.
and the law uses the word "and" between these 3, right? Did that cause any arguments?
It did. The mother's lawyers argued "and" meant all 3 conditions had to be ticked off, strictly, like a checklist.
Makes sense grammatically.
Yes, but the father's side suggested maybe they were more like categories the court should weigh up. Look at the whole picture.
Interesting distinction. How did the courts handle that?
Well, interestingly, both the Durban Court and the Supreme Court of Appeal kind of sidestepped making a definitive ruling on the "and" interpretation, because they ultimately found that, on the facts, the father had actually met all 3 requirements anyway. So whether it was strictly conjunctive or categorical didn't change the outcome in this specific case.
Got it. So let's unpack the mother's appeal arguments. She was essentially saying the Durban court got it wrong, that the father hadn't met all 3 criteria.
Exactly. She conceded he met the first one, identification, but she strongly argued he failed on the other 2, contribution to upbringing and contribution to maintenance.
What was her reasoning?
She claimed his contributions weren't enough, weren't significant. She also threw in this argument that he wasn't technically exercising his rights because he happened to be traveling overseas right when she left with the child.
And she brought up some quite personal stuff too, didn't she? Accusations about his lifestyle.
Yes, she did. Things like not being at the birth, claiming he wasn't a willing father initially, that his visits were too short. And then, yes, allegations about drug and alcohol use, violence, even possessing a firearm.
That must have muddied the waters considerably. How did the court separate the legal issues from the personal conflict?
Well, the court had to be rigorous. They emphasized that many of these accusations, while serious in other contexts perhaps, were actually irrelevant to the specific requirements laid out in Section 21B.
So things like his alleged lifestyle didn't negate his attempts to contribute.
Not according to the court's reading of the specific section. The court focused on what the father did do and, crucially, tried to do. And what emerged, based on the evidence, was a picture of a father demonstrating willingness, but being actively frustrated by the mother.
Actively frustrated? How so?
Evidence suggested she'd received legal advice quite early on, even during pregnancy, on how to make things difficult for him, how to potentially leave for England quickly. The court noted she seemed quite upset about the relationship ending, about his new partner, and this appeared to motivate her actions to limit his involvement.
Okay, so despite that resistance, what specifically did the father do that convinced the courts he met requirements 2 and 3? Let's start with number 2, contribution to upbringing.
Right. So the court acknowledged the mother blocked him from scans and the birth. But they highlighted that he did visit the baby regularly after birth. He introduced S to his own family, his extended family. He even took practical steps for the future, like taking out an endowment policy specifically for S's upbringing.
That sounds like more than just casual interest.
Exactly. And there was evidence, like SMS messages showing him asking for more contact, expressing his desire to be involved. The court felt these showed his good faith attempts were genuine, even if the mother saw his visits as some kind of favor she was doing him.
Right. And requirement 3, contribution to maintenance expenses. She argued his contributions were insignificant, didn't she?
She did. But the court looked at the facts. He bought practical things. A heater, a pram, a car seat, clothes, nappies, other necessities. He even built a changing table for S himself.
Wow. Okay.
And importantly, he offered more. He offered to add S to his medical aid plan. He asked for her bank details so he could deposit maintenance money directly.
And she refused these offers.
Yes, the evidence showed she declined them. So even though she tried to frame his actual contributions, about $14,000 over 4 months, as insignificant or just gifts from his parents, the court disagreed. They saw it as a substantial contribution, especially considering his further offers were actively refused.
This really comes back to how the court interprets those phrases, contributes and reasonable period. What was the Supreme Court of Appeals thinking there?
This is key. They agreed with the lower court that these are elastic concepts. There's no fixed rand amount or number of hours per week.
So it needs context.
Exactly. It requires a value judgment based on all the facts of the specific case. The lawmakers, the court reasoned, deliberately didn't put qualifiers like reasonable or significant before the word contributes.
Why is that significant?
Because it shifts the focus. It's less about the amount and more about the ongoing nature of the contribution and, critically, the good faith attempts. The court actually warned against setting the bar too high, against demanding significant contributions in a way that could unfairly discriminate against an unmarried father whose genuine efforts are being blocked by the other parent.
That seems really important for fairness, especially when relationships are messy.
It is. It upholds the child's constitutional right to care from both parents and prevents one parent from effectively vetoing the other's rights simply by being obstructive.
Okay, and quickly, what about her argument that he wasn't exercising his rights because he was out of the country when she left?
Yeah, the court shut that down pretty quickly. They called it legally untenable. Meaning it just doesn't hold water legally. The evidence was clear. He was away temporarily, and she knew he was coming back. A temporary absence doesn't just switch off parental rights that have already been established and consistently shown.
So pulling it all together, the Supreme Court of Appeal confirmed the Durban court's decision.
Yes. They ruled definitively. The father had acquired full parental responsibilities and rights under Section 21(1)B by November 2012.
And because of that,
he was a co-guardian. And as co-guardian, his consent was absolutely legally required for S to be removed from South Africa.
Since he didn't consent and she didn't get a court order,
her removal of the child was unlawful. It was a breach of his established parental rights. Full stop.
So that clearly answers the original question posed by the English court. No, it was not lawful for her to remove the child.
Exactly. But the case's impact goes further than just answering that question. It sets a really important precedent for how Section 21B is interpreted and applied in South Africa. It strongly reinforces the idea that the Children's Act aims to promote equality, Section 9 of the Constitution, and fundamentally the child's right to parental care from both parents under Section 28 of the Constitution.
It really drives home that point about good faith attempts, doesn't it? Even if the other parent makes it difficult, the genuine effort counts significantly.
Precisely. It's a caution against demanding an overly high, perhaps purely financial threshold for contribution that could lock out a willing father, especially if the mother is actively creating barriers. The use of the present continuous tense contributes also emphasizes that ongoing pattern of involvement which the court found this father had shown.
Okay, one last point. The costs. The mother lost the appeal and the court ordered her to pay the father's legal costs. Why is that significant?
It's quite significant because in family law, especially cases involving children, courts often lean towards each party paying their own costs. The thinking is usually that both parents are, in theory, acting in the child's best interests, even if they disagree strongly.
So ordering costs against her suggests the court took a dim view of her conduct.
It does. The court explicitly noted that the father was forced into this litigation simply to get the South African law clarified for the English court. They described the mother's approach throughout as deliberately difficult and obstructive. They mentioned her introducing scurrilous and vitriolic matters, those personal attacks that were irrelevant to the actual legal question. They felt she persisted with frivolous claims, purely to deny the father his rights. The court saw this conduct as bordering on an abuse of the court process.
Wow.
So the costs order wasn't just about money, it was a form of censure. It sends a message that while the child's best interests are paramount, using the courts in an obstructive or vexatious way can have real financial consequences.
So when we boil it all down, what's the big takeaway from KLVC v. SDI?
I think it's a powerful reminder that the law aims to protect the rights of all parents, married or unmarried, and fundamentally the child's right to have both parents involved in their life where possible.
And it really underscores the absolute necessity of getting proper consent or a court order before making huge decisions like moving a child internationally. You can't just go.
Absolutely not. This deep dive shows the courts carefully interpreting laws like the Children's Act to balance parents' rights with the child's best interests. It shows how legal language contributes, reasonable period, good faith, gets its real meaning through these tough cases. It's proof that parental responsibilities and rights don't just disappear when a relationship ends, they persist, and they are legally protected, even across borders.
It definitely leaves you thinking, doesn't it? How can we better ensure that our legal systems truly support parents who are making those good faith efforts to co-parent, especially when things are acrimonious? And maybe what more can be done systemically to stop these conflicts escalating into these huge, costly international legal fights in the first place? Something to think about until our next deep dive.